Is my ma'am, now my voice is clear? Can you hear my voice?
Yeah. Yeah.
Sorry, ma'am. Sorry for inconvenience. She received Dr. Sarojini Naidu International Award for Working Women in September 2021 and received Best Teacher Award in Applied Science by Global Security of Basic and Applied Science, Mumbai, India. She also received Best Teacher Award, Best Achievement Award, Sincerity Award, and Kaveri Award for Excellence. Successfully completed domain certification in IPR on NPTEL Swayam platform in courses are Innovation by Design, Managing Intellectual Property in University, Patent Law for Engineering and Scientists, Patent Drafting for Beginners, Patent Research for Engineers and Lawyers, Roadmap for Patent Creation. She also published articles on intellectual property rights, copyright, an important element of intellectual property rights, getting patent in India and foreign countries, elaboration on important section of Indian Patent Act 1970, imperative tips for patent drafting, patent licensing. Dr. Jayashree Bengali ma'am to deliver the today's session overview on intellectual property rights and patent research for innovation. Now I invite Dr. Jayashree Bengali ma'am to deliver her session. Welcome you ma'am. Now the time is yours.
Yeah. Thank you so much for such a nice introduction, and thank you so much for giving me this opportunity to share my knowledge with all of you. Is my screen is visible to all of you?
Yes, ma'am.
You can see this?
Yes.
Okay.
Yes, ma'am.
Okay. Today I'm going to talk on the importance of IPR patents and patent search for innovation. Means how you are going to search for a particular patent if it is previously available or no. That search, how to do search for that I'm going to explain. So presentation outline will be introduction to intellectual property, types of intellectual property and IPR, importance of IPR and filing patents, getting patents in India and abroad, and patent search for innovations. My voice is clearly audible?
Yes, ma'am.
Okay, okay. So if there is anything problem occurs in between, please interrupt me. Okay, so we will just start with the basic definition of the property. So property is nothing but you can say that it's a physical property. There are two types of property. One is the tangible and other is the intangible. Tangible property means the property that we can see, and intangible property means that is the intellectual property. So the property which is not physically present is called as an intangible property, and we are talking about the intellectual property. So this intellectual property is a type of intangible property. So WIPO is the World Intellectual Property Organization, and it refers to the creation of the mind, such as invention, library, artistic work, design, symbol, etc. So these are all comes under the intellectual property. Now, what is intellectual property right? So right means it's a legal right conferred on the intellectual property. So it is, in short, it is popularly known as a IPR. Now, why this IPR is required? So what is the need of this intellectual property rights? So why it is required? Because you know that this history and all this thing, I think it is not required to explain, but just we will go through it. So in the 1873, when they have started the exhibitions of the invention, and then they some of the industry, they found that their invention can be stolen by the others. So at that time, actually, this people felt that we should have something which will protect their invention. So from that a century, this protecting the intellectual property comes into the picture, and then people have started protecting their intellectual property, and then this IPR comes into the picture. It provides the incentive to the individual or researcher, then it gives you the recognition, then it gives you the material award, and also it gives you the rights of that original products. So IPR mainly deals with the rights, creation of those things, and its enforcement. Now, where this IPR IP can be created? So anywhere. So in colleges, schools, university, research lab, company, anywhere this IP can be generated. Now, what is the history of this IPR? Is that at the beginning of the 20th century, uh, many countries were either isolated or at the war, and at that time, actually, people felt that we should have a particular IPR for our country, and then it was started in by the US, and they formed the intellectual property rights, and then other countries have started forming their IPRs. So this World Intellectual Property Organization, it's a basically global forum which have the services, policies, information, and it is a self-funding agency of the United Nations. So 193 member states are there, and headquarter is at Switzerland. So this actually there are two convention, Paris Convention and Bonn Convention, that we will see in the further slides. So what is this Paris Convention for the protection of industrial property is nothing but this gives you the rights and protection for your property in other countries also. So if you file a IPR in India, then that intellectual property is protected in India only. So if you want to protect your property in other countries also, you have to follow the rules of this Paris Convention. So, and it's a treaty, means you have to sign the agreement. So India has signed this agreement. The second one is the Bonn Convention. So this is adopted in 1886, and it is for the authors, musicians, poets, painters. So it is basically deal with the protection of works and the rights of their authors. So copyright is actually under this Bonn Convention. So India has the member of this Bonn Convention from 1928, and Paris Convention, we have signed the agreement in 1998. So more than 25 or rather 30 international treaties are there, and these were administered by the WIPO. Then another international IP standards are the TRIPS and PCT. What is the history of IPR in India? So in India, Patent Act was introduced in 1856, and then it was 1911. The Indian Patent Acts and Design Act comes into force, and then in the Patent Act 1970, actually this Patent Act 1970 we are following today also. So there were a lot of amendment done in the act, but the basic act was framed in 1970, and we are following this Patent Act. So what are the types of intellectual property? So these are the basic types. One is the industrial property. In this, trademark, industrial design, geographical indications, then patents. These are comes under this industrial property, and other is the copyright. So copyright is not the literally artistic works such as the novel, poem, plays, films. So all this comes under the copyright. So these are the different types of intellectual property rights. So starting from the patent, copyright, trademark, industrial design, then protection of integrated circuits, geographical indication, biological diversity, and plant variety. So these are the basic types of the IP. We will start with the patent. So patent were one of the first type of intellectual property right, and you know that it is very, very important to protect your invention. So if you just see around you, there are so many things that are protected under this Patent Act. So starting from the electric lighting patent held by the Edison and Swan, to the iPhone patent held by the Apple, to the maybe the toothpaste, to maybe the toothbrush. So all these are patented, so that their design or maybe their invention cannot be stolen by the other people. So what is basically patent? Patent gives exclusive right to its owner to exclude others from making, using, selling, offering for sale, or importing the product or the process. It may be the process for producing the product without his consent. So that is very, very important. The second type of IP is the trademark. You might have heard this. The trademark can be a sign or logo, and a trademark helps company to make their recognition and reputation. So we have seen these trademarks. So many trademarks we are seeing around it, starting from the Nike, then McDonald's, BMW, Ford, then Amul. So TM, this is left side. This TM or this R in a particular circle, it indicates that that particular name is a trademark of a particular company, and you cannot use this. So this is the trademark. The third one is the geographical indication. So geographical indication is basically it's a special qualities which are influenced by geographical climate or soil, and you can protect this under the GI. So this GI can be registered under the Act 1999 in India. This also you have might have heard about this because Tirupati Balaji Laddu is a GI, because this type of laddus are speciality of the Tirupati Balaji. So Darjeeling tea is a GI, then Banarasi silk is GI. So all these are the GIs and they are protected. So you cannot use this. The another example of GI is the basmati rice, then Kurg orange, Darjeeling tea, Alfonso mango, Kolhapuri chappal. So there are so many things comes under the GI. The Darjeeling tea becomes the first GI tagged product in India, and it's a very interesting story of this Darjeeling tea, that we have to fight for this to get the GI for this Darjeeling tea. It's a history. I will not go into the depth of this, but just a conclusion, I will explain that the Tea Board of the India, which is formed in the Darjeeling, they have to actually apply for the registration of the word Darjeeling and Darjeeling logo, and then for the GI. So we fight for this for a long time, because Darjeeling tea was given the GI status in 2003 in India, but not in the abroad country. So that was granted in 2011 by the European Union. So we have to fight for that, and we have successful in fighting, and now we have got the GI for this Darjeeling tea. This is the first actually GI. Now we have more than 100, 200, or rather more than 300 GIs India has, and they are for the specially for Hardi and other products. The next one is the industrial design. So industrial design is, according to WIPO, is this industrial design means it's ornament or aesthetic aspect. It can be three-dimensional, it can be two-dimensional, and if you just see the examples, you will get the clear idea about it. So this first one is the Coca-Cola bottle. So the shape of this bottle, design of this bottle is protected under the Design Act. So shape of this sandal is also protected under design. Then this Nike shoes design is protected. Then you can see the number of pictures shown in this slide. So all these are the shapes, and their designs are protected under the Design Act. So other person cannot use these designs. The next one is the trade secret. It is very interesting thing, or interesting type of IP. The trade secrets are intellectual property rights on the confidential information. Means what? The invention or its process is not patented. It has kept the confidential. Means it's a secrecy. It is not registered anywhere. So it is called as a trade secret. So I will give you just example. So you can just search for this, and you will get the interesting stories of this Coca-Cola also. This Coca-Cola recipe is one of the most famous trade secrets in the world. So it's a trade secret because only a select few people of the Coca-Cola know the exact recipe of this. So Google algorithm and the processes of the Intel, they are all comes under the trade secrets. They have not registered anywhere, so it's a confidential information which is kept with the company. It is too much risky, but still they have kept it as a secret, and they are not registered anywhere. So this Coca-Cola is, as I said, it's a very famous example of this trade secret. So it's a few people know about it from the company, and they there are conditions that all the people who knows the recipe, they cannot travel in one plane and all these things to just secure it. Then KFC kitchen recipe is also one of the trade secret, and the Google page rank formula is also another type of a trade secret. The next important of IP type of IP is the copyright. So copyright protects the rights of creators for his her own literary and artistic work, and the term copyright refers to the right to copy. So if you have copyright of your material, then other cannot use it. So it's illegal. So copyright protects the expression of an idea and not the content or idea itself. If you want to have the if you want to protect your idea or invention, you have to go for the patent. Copyright means whatever you have written or whatever it's a expression of that idea, you can protect under the copyright. So these are the things which comes under the copyright. So it may be music work, artistic work. So you know that all the songs, then lyrics of that songs, they are all copyrighted. So if you want to use, suppose in a particular function or in a party or maybe for any event, if you want to use a song. Yes, any questions from the audience, or I am not audible? Am I audible?
Yes, ma'am.
Okay, I thought that someone has raised any query. Shall I go ahead?
Yes, yes. You may.
Okay. Okay. So if you want to use a particular song of from the film to your suppose any function or party, you have to take the permission of that company to use that particular song. Okay, so many times in the advertisement, you have seen in advertisement many times a particular song is used. So that advertising company has to take the permission of the company of the particular song has in the film. So they have to take the permission of that producer. So this come all this comes under the copyright. And you have seen you might have seen this C and this circle. So it indicates that the material is copyrighted, and it's a once you have taken the copyright of your material, it is to the 60 years. Okay, so the period is counted from the year following the death of the author. So it is a long period, the IP is protected. The next is the plant varieties and farmer rights. So here, if you want to suppose provide an effective system for protection of a plant varieties, so farmers are doing research and they are trying with the another breed. So if there is an invention of this breed, they can protect their plant breed in the under this plant varieties and farmer rights. Then protection of integrated circuits. Now you know might be knowing about this because IC, that is integrated circuits, are the basic thing of today's electronics, and this a layout design of this ICs or integrated circuits are protected under this. So if you just see the Intel, maybe the Intel or Microsoft, all these chips or microprocessors or microcontroller or maybe the other electronics things, all these layout designs are protected under this integrated circuit layout design. Last one is the biological diversity. So if it is basically referred to the genetic material of actual or potential value, and traditional knowledge means the in our case of India, maybe the yoga or maybe other things comes under this. So this are the 8-9 types of intellectual property, and among this, the important one are the patent, copyright, trademark. All these are the important types of IP. And today I'm going to focus on the patent, how to file the patent and how to search the patent. So these three things related to patents we are going to see. So till this point, we have just seen the scenario of the IPR and their types. Why it is important to protect your invention? So what is the importance of patenting invention? Now this is a very famous thing again. It's a first instant noodle. So now today we are using the noodles, Maggie, and this all these things regularly day by day life. But this is the first instant noodle. So this Momo Fuku and Nissan Food Products Limited, Japan, they have just thought about that we should have something or some type of noodles which can be eaten anywhere with just a bowl and chopsticks. So they have invented this, and his research resulted in a successful development of world first instant noodle. And they have actually, it's a turned out to be a big hit, and crude imitations appeared in the market. So people are now again copying the thing. So they have protected their intellectual property by way of a patent, and then they gain a very huge profit, I can say. Then here you can see, if you just consider just a bottle of this Coca-Cola, how many IPRs are there in just one product? So its logo is example of trademark. Shape of the bottle is protected under industrial design. Patent may be have obtained in respect of bottling the equipment. Copyright in respect of the text or database or artistic work appearing on the bottle itself. And again, as I said, the recipe of the Coca-Cola is again the type of a trade secret. So more than one IPR is there for one product. Again, this is the another example. It's a CD player, so industrial design protection for 3D. So so many things in just this one CD player you can protect, and rather you have to protect. Otherwise, people will start copying it, and you will get the now we usually say that it's a made in China product. So all the things are copied by the other people, and they just put that product in the market with low rate, and people buy that products because the cost is less. So it should not happen. So all the things should be protected. So moving to the next section is the laws of intellectual property right. Now if you want to suppose file a patent, how you will file the patent? So that there is a particular procedure. There is a special forms, application forms that you have to submit. So everything detail about all this, everything we will just see in the next section. So intellectual property rights acts in India, these are the main acts. Copyright Act 1957, Patent under Patent Act 1970, Trademark under Trade and Merchandise Marks Act 1958, and the Design under Design Act 1911. So we are following this main act till today also. Many amendments are done in the act, but we are following this act. So coming to the patents and the Patent Act 1970. So as I already explained what is patent. So patent gives the exclusive right to its owner to exclude others from making, using, selling, offering their product. So this is actually the patent. It gives you the exclusive right to the owner or to the inventor. So now just imagine that what can be patented means any process or any product cannot be patented. It should be new, and there are some conditions that should be fulfilled. Then only that you can file a patent for your invention. So an invention, if you want to define, it can be defined as a process or product that offers a new way of doing something or new technical solution to the problem. It should be new. That is the basic condition. The invention should be new, which is not part of existing body of knowledge. It should not be existing. It should be new. So invention must be, so there are three conditions that should be fulfilled. First one is useful. The invention should be useful, it should be novel, and it should be non-obvious. Now we will just see what is it exactly the meaning of these three words. Now, to be novel, an invention must be different from anything else. That is public knowledge. It should not be known to the public before filing the patent. So public knowledge includes anything that has been previously patented. So anything that has been written about in a publication or anything that is already being sold in the open market. So whatever available to the public, your invention should not be the part of that. That is nothing but it's a meaning of the novel. To be non-obvious means the invention must not be easily perceived by a person of expertise. Means there are expertise person in a particular field. So you are filing a patent for a particular invention, so that should not be easily perceived by that person of expertise. That is the meaning of non-obvious. Third one is the useful. Whatever invention you are patenting, it should be useful to the society. It should be useful to the industry application. So this is the meaning of the useful. So if your invention is satisfying all these three conditions, then only you can go ahead with the filing a patent of your invention. Otherwise, no. So these are the main basic conditions to file a patent. Now this again is the just example is given that this grinder is a patented technology. Now about the patent law means how, suppose any person from the audience, now they he or she wanted to file a patent, how they can file the patent. So this about filing the patent in India and abroad, that we will see, and then we will go to the patent search. So this is the patent law 1970. According to the law, what is the procedure for that we will see. So Now, patent application can be filed physically at the patent office, or you can file it online also. So there is a site, IP India online.gov.in. So application form is available on the website also. You can fill it online, or you can file it physically at the offices situated in Chennai, Mumbai, New Delhi, or Kolkata. Then, now, as I said, India has now signed so many treaties and international agreements. So we have already signed the TRIPS agreement. The patent 1970 has undergone 3 amendments. So these are the basic, actually. Latest, it was amended in 2016, then 2019, and also in 2020-22. This act was amended, and introduction of the product patent protection for food, pharmaceutical, and chemical invention. So these things are added. And in 2016, the government has added startup in the law. Now, there are a total 167 sections of this law. So I will just explain one section. So what is patentable and what is not patentable? So what can be patentable, that we have just now discussed, that is, the invention should be non-obvious, novel, and useful. These 3 conditions. Now, what is not patentable? So according to the section 3 of Indian Patent Act 1970, the invention which is playful, laughing, so this is not allowed. Invention related to atomic energy, or maybe traditional knowledge, or contrary to natural law, injurious to human health, all these are not allowed to patent. Then any process for the medical or surgical, so this is also not allowed. Then computer program or algorithms is not allowed for the patenting. If you want to protect your algorithm, you have to take its copyright, not the patent. Then literally, dramatic, musical, this all things undergo to the copyright, not in the patent. So presentation of information, topography of IC, all this is not allowed under the Patent Act. Then according to the section 3A, it disallowed the patent for machine that gives a more than 100% performance, which is not possible actually. The machine cannot give more than 100% performance. So that is not allowed according to this section. 3B disallowed the patent for gambling machines and housebreaking. So this is also not allowed. This 3D is very, very important section of the patent law. Why? Because see, in 2020, when this COVID has, what I can say, pandemic situation occurs, and because of the COVID, we are stuck up in the houses, and it's a horrible situation we have faced for last 2 years, 2020 to 2022. So this 3D section is related to what is basically, it's related to pharmaceutical company. Why I am relating this to the COVID? Because it is related to the vaccine, as vaccine comes under the pharmaceutical. So this is a vital role in protecting the public health and restricts monopoly of the pharmaceutical company. Means it is known as evergreening. This evergreening means what? It's a process by which a company brings minor modification in the patented product and gets new patent. Because see, if you just have observed, though I have not mentioned, the duration of the patent is 20 years. So suppose one company has taken the patent of a particular medicine in 2000, then in 2020, that protection will go, and that invention is available publicly. So company don't have any right on that invention after 20 years. Okay. So what these pharmaceutical companies are doing, they are doing this evergreening. Evergreening means what? They just change something in the process, and then again they file the patent, and again they protect their invention for the next 20 years. So it is called as evergreening. So according to 3D, it is not allowed, because otherwise the cost of this medicine will go on increasing, and the people who are in the backward class, they cannot afford this. So that is the main issue with this. So according to this law, it is not allowed. Now, getting the patent in India and foreign countries. How you can get the patent in India and foreign countries? What is the procedure for that? So this is the stepwise procedure. Okay, before moving ahead, any doubt till this point? As I have made my screen full screen presentation, I can't see the audience. Any question from the audience? Shall I go ahead? Shall I go ahead?
Yes, ma'am.
Okay, fine. So what is the procedure for getting grant of patent in India? Now there are a number of steps in this. So first is you have to file the patent application in Indian Patent Office. As I said, you can file it offline or you can file it online. Then there is a formality check of the documents which has to be there with the application. So IPO will check all the documents. Then this invention, whatever invention you have applied for the patent, that will be available publicly. So publication means what? This invention will be available on the IPO website. Why this is available on IPO website? Anyone from our country, if you want, if any person from the country wants to raise the objection for this particular invention, they can raise. That's why the invention is available publicly and it is uploaded on the IPO website. The fourth step is the request for examination, means we have to request the IPO for examining this documents and the invention. Then the committee will examine, then they will issue the first examination report, then response from the applicant, means whatever query raised by this IPO in this first examination report, applicant has to give the answer to that. Applicant has to respond. Then pre-grant opposition means before granting the patent, if anybody wants to oppose this, they can oppose it. It is known as a pre-grant opposition. Why pre-grant? Because the patent is not granted yet. Then again, if anybody raised pre-grant opposition, then it is examined. Then again, it is discussed with the applicant, and if it is okay, it will go ahead. Or otherwise, if opponent one, then this granting of patent cannot be happened with that particular invention. If it is okay, then the patent is granted to the particular inventor or the applicant. And the last one is the post grant opposition, means after granting the patent also anybody can oppose this. So this is known as a post grant opposition. So these are the basic steps of, or rather procedure for getting the grant of patent. So this is just in a pictorial format. I have just mentioned this. These are the just steps, whatever just now I have explained. Now there are again the first step when you are filing the patent application. So you have to just select the patent application according to your requirement. So there are 2-3 types. So provisional application means what? If it is filed when the inventor is not quite ready with his invention, means the invention or research is in process. But if you want to file it before completing the invention, then it is you have to file this through this provisional application form. Why this is so? Because if you just see, the procedure is very long, and if you file the patent, suppose today, after 2, 3 or maybe 4 years the patent is granted. So it is a long procedure. So if you want to start the procedure early, then you can start with this type of application. The complete application is nothing but if the invention is fully and completely done, then you can go for the complete application. Now, Patent Corporation Treaty, I have already explained this PCT. If you want to protect your invention in other countries also, then you have to follow the method of this PCT. If you don't follow this method of PCT, your invention is protected under the Patent Act in India only. So that is the difference between the regular patent application and PCT application. Then this is the divisional application. Divisional means it is application divided out of first mentioned patent application. The next is patent of addition, means you have already applied for a particular invention to get a patent, and you have done, meanwhile, you have done some improvement or modification in your invention, then you can add this through this patent of addition application. So these are the type of application. You have to select the application according to your requirement, and then you have to file the application. This is just a format I have given here because this filing or preparing the patent application is very, very important. That's why we have to consult the patent agent. Otherwise, we can write down the application and we can file it, but it's not like that. You have to go to the expert person of this, and then you have to actually prepare a patent application. So it starts from this format is given by the IPO itself. It's a standard format, and you have to file the patent application in this format only. So first is the title, field of invention, background of invention. Background of invention means what is it exactly, what is its background, what previous people have done related to this invention. You have to mention everything. The statement of objective of invention, statement of invention, a brief summary, and then exactly what you are claiming. Claims are very important because in the claim, whatever you have written down, 1, 2, 3, 4 claims, the protection is for the claim only. So the forming this claim is very important because you will get the protection for the claims. So again, abstract and drawings. So this is the standard format of the patent application. So this point I have explained. If you want the protection in other countries, you have to follow the method of PCT. So this PCT does not provide a grant actually. The grant of the patent is provided by the particular country. Means if I am in India and I want to protect my invention in other countries also, I will file the PCT application, but other countries are not giving you the grant. Your country will give you the grant and the invention is protected in other country. So this PCT does not provide the grant of the patent, just the method of applying the patent. So these are the just deadlines. As I said, it's a very long process. So minimum 2-3 years it takes to grant a patent. So this is the particular time duration for each step. So we have to follow this very strictly. And whatever is the suppose first examination report has come. So AFR should be replied by the applicant within 12 months only. Suppose IPR has said some queries in the first examination report. The applicant should reply, should give response within 12 months. So this actually timeline applicant has to follow. Then, as I said, patent application fees is 1600. Now it is, I think, increased little bit, but it is around 2000. And if application is filed through lawyer or patent agent, it is 40,000 to 70,000, and it took a 3 to 6 years are required to grant a patent in India and in foreign countries also. So it's a long process. So before filing patent application, inventor can search previous patents to verify and confirm similar invention is not patented previously. This is very, very important step. Because suppose I wanted to file the patent for my invention. So first I have to check whether already somebody has filed the patent for similar type of invention or no. That I have to first check. So this patent search is very, very important in that case. So how we will search a particular patent? Now there are free sites are available where you can search the patent. Who have already filed or already granted the patent, and some are the paid sites also. So this Google patent, I will just click and show you. If it is go to the site, just a minute, it is opening. On the Google online, if you just write or type Google patent, then that site will get opened. It is opening, just a minute. Can you see my entire screen?
Yes, ma'am.
Yeah, it is actually opening. Just a minute. So there are free sites available on which you can actually search a particular patent. Now, can you see the Google patent on your screen?
Yes, ma'am.
Okay. So now here you can type anything and it will give you the granted patent list. Suppose I will just type maybe mobile. It is uploading actually. Mobile. If you just search anything on this site, you will get the. See, now it is opening. Okay. So
Yes,
just see, I have typed just one word. Now, mobile, just a mobile. I have not written mobile phone or anything. So related to the mobile or mobility, whatever patents already filed, the list is displayed on the site. Can you able to see the list?
yes, ma'am.
So it is like that. So you can just search anything actually. The another site is Espenet, then
Ma'am?
Patent Scope. Yeah,
Sorry for the interfere, ma'am. I'm
yeah.
Deepa Relur, ma'am. What is meant by WIPO, ma'am?
Just can you repeat the question?
WIPO, WIPO.
World Intellectual Property Organization. World Intellectual Property Organization. I have explained this in the first slide itself.
Yes, ma'am. But here shortly given, that's why I have asked, ma'am.
Okay, basically it's an organization in the US, and this organization have framed the all the patent rules and everything, and all the countries who have signed that particular agreement, they have to follow the rules. So it's a have particular database also. So you can just see that WIPO. You can just type WIPO on the Google, and you can see the entire site. Everything is available on the site itself. Okay, so it's a basically organization. It has the main office in Switzerland.
Okay, ma'am. Thank you for your applause, ma'am.
This is another site is Esquinet Patent Scope. I am interested in just wait to show the Indian site on IP site. How you can just a minute. That is very important because if you are filing the patent in India, you have to search the patent on IP site. Just a minute. Due to internet, actually, it is. So this is the site actually in PASS. If you just click on the link, you will go to the IP India site, and here you can search the patent granted patents by the IPO office, and you can search it by the name, by the subject, by the other classification. So there are number of search options are given on the site. Just wait. It is not opening. Just a minute. Just give a second so that the site will open. It is quite interesting to see this because there are lots of options. There are logical parameters. Means suppose I wanted to search a patent. Suppose I am doing a research in a particular subject. Maybe what I can say. I can take an example of suppose toothbrush. Simple example. So how many have patented a design? So see, can you now able to see the screen?
Yes, madam. Yes.
Yes. So this is the screen of the IPR India .gov.in. So it is an INPASS, that is Indian Patent Advanced Search System. Here you can search the patent. Means what? Your granted patent list. So whatever topic or subject you are having invention, then you can search it before. Now just see how many fields are there, and logical operators are also there. So first is the select search field. So by application date you can select, by title you can select, maybe abstract. So whatever information you have, you just type a keyword here and it will give you the result. Now suppose we can just try one of this. It's a little bit slow actually, that's why it is not coming. Yeah, see. So if application date, suppose from which date you want to search, application date, publication date, date of grant. So whatever you can have, you can just select it. Title, you can just have the suppose abstract. Then another field is a suppose, I'm just randomly selecting this. Okay. Then suppose you can write down the date, means what, from to, means from this date, means suppose you want to check a patent, granted patent from maybe the this thing December 23, or maybe we will go back and see last, from 11 September to till today, suppose you want to see. So you can just select a date. Now today we are at 10, so till today you can just see, and go this thing and you can search. You have to type a captcha code here and then you can search. Okay. Now this operators. Now if you just see the right side of this, now see, again I'm just explaining the entire thing because it is taking time, so I'm not giving you the demonstration, but I will explain the field. So if you want to check the published patent, published means what, it is not granted but it is published on the website, so you will tick this publish. Okay. If you want to check the patent, whether the patent is granted or no for from particular field, you will click on the granted. Okay. Now again, the logical operator means what, whatever you are selecting here, this and this, means if you are giving the two suppose subjects, means the design of the toothbrush and the material used for the toothbrush, so it's a and. It can be or this, or it can be this but not this. So there are three logical operator for searching this. So you can search by using these three logical operator also. Then you can just go through the other fields. You can just see here, you can type complete specification. Now vehicle digital identification, or maybe whatever it may be, if you know the patent number, if you know the applicant name. So by any field you can search on this site. Okay. And why to search? Because as I already explained that before filing the patent, this patent search is very, very important, because whether the invention is patented before or not, that you have to check. So that thing first we have to check, and then we have to go for the filing a patent application. Because you are saying that no, my invention is new, novel, useful, and I wanted to file the patent. So it's a lot of money and lot of time, lot of energy is required for this entire thing, patent application and granting the patent. So before going into this procedure, you have to check that whether it is available, whether similar kind of invention is patented before. So for this purpose, this thing has to be done. And if you are filing the patent in India, not in the abroad countries, this in-pass is very important. So it's actually what I can say, it's a vast topic, because entire session can be actually organized on the patent search. It is very vast. There are classifications, there are as I said, different logical operators, different fields. By using you can search the patent. So I have just explained few things about this. So this is about the in-pass. So it's a government site, and you can search the patent on this. The another is the lens. I am not clicking on it because it is taking time. Okay, so these 5-6 whatever sites I have explained, they are free sites. So you can search on the free patent databases, and these are the search engines which are useful in identifying prior art on your own. Means inventor can have the basic search, means similar invention is granted previously or no, so you can just search by your own on these free sites. But however, a systematic review of patent or a focus per art search is needed to before filing the patent application. So it's a vast database, thousands lakhs of patents are granted, and you have to search from this huge database. So it requires expertise for this, and that's why who can search patent according to their classification, that person, that agency or company is required to do this patent searching. So this is the list of patent databases. These are the paid actually patent search tools. So few examples I have listed here. So many other examples are also there. So when really inventor want to file a patent, this paid size that person has to use. Rather, we have to contact the patent agent company, and then we have to file the application. So that is the better option for this. Any doubt till this point?
Madam, I'm Dr. Sairam from Laila College, Vijayawada.
Yes, sir.
Thank you very much, madam, for giving a wonderful clarification between patents and copyright. You explained how to check existing patents. How do I check if a copyright is already in use? Can I use copyrighted material for education purpose?
Yeah. So see, actually my focus of this session was on the patent, not the copyright, but I will answer your question.
Okay.
Your question is, in the education fields, actually we are using material which is available on the Google.
Yes.
Okay. Yeah. So some of the actually material is copyrighted, and you cannot directly use as it is legally.
Okay.
Legally we cannot use it if it is copyrighted. If it is not copyrighted, then you can use it. But many times we are using, suppose now a particular student is suppose writing the PhD thesis. Okay, so in the PhD thesis, the second chapter always is a literature review. So we are doing the literature review, and from where that person will do the literature review, from the Google or maybe the whatever papers he has. So whenever he is writing something in that chapter of thesis, he should change the sentences somewhere. Same sentences which are available on the Google, it is not advisable to copy it and use it for the thesis purpose. But for educational purpose, it is allowed. If you are using some of the maybe material for educational purpose, then it is allowed.
Okay, madam. Thank you.
Any other query?
Ma'am, this is Dr. Monisha from Chennai, ma'am.
Yeah.
Yeah. You said that pattern needs to be for publication. How many days, ma'am, it takes?
For publication for 12 months, you have to actually, when you file the patent application to the IPR office,
Okay.
That invention is uploaded on the website, and it is kept there for 12 months for
Okay.
any objection.
But here we can find in some WhatsApp groups or some patent agency where they're getting published within 15 days, ma'am. How it is possible?
No, it's not possible. No.
But they are giving on a sharing basis. It is they are getting published on the online within 15 days. It is through legal or it is something fishy. We can't find it right.
Yeah, it's something fishy. Now see, mostly I observed that mostly are from the education field, I think.
Okay.
Am I correct? Okay.
Yes.
So now what is happening in the education field, I just give you the scenario. As I already explained the entire process of filing the patent application. So if you just remember, the third process is publication, means what? Your invention is publicly available on the website. Okay, IP website.
Yeah.
Now teachers from the education fields, they are actually saying that the patent is granted and it is published on the IPR in this site, but it's not. The patent is not granted, only it is publicized for any objection. on the IP side. But it's yeah, people are misusing it. It's not like that.
Thank you, ma'am.
Yeah. Any other question? Okay. So this is the last step actually. If the patent is granted to the inventor, what is important is, because see, you have gone through a rigorous process of taking a grant of for your invention, and the now invention is patented and protected. So what is the next step is that you should commercialize it. If you're keeping it, because see, another observation from the educational field, so teachers now they are just taking the patent for the sake of maybe cash or maybe their appraisal. They are taking the patent and they are saying that this is published on the website of IP India, and now this 1, 2, 3 are done, and they are putting in the maybe the addition of their biodata and keeping as it is. But it's not like that. If you have done so much of efforts and the patent is granted, then commercializing the patent of your patent or invention is very, very important. So this is also another like, a vast topic. So in 2 slides I will just brief about it. Licensing a patent is very important. Licensing means what? According to the section 48 of IPA 1970, this patent team is inventor has a right to authorize the person who can use his invention through licensing. Means you can have invention with you, you can just have an agreement with the company, and you can give the rights to that company so that that company will go for the production. So licensing is very useful way of raising finances. So if you don't have any finance, it's okay, you can have an agreement with the company, and then you can do its production through that company, and have a such agreement that this much shares will go to the inventor, this much share will go to the company. So the main advantage of licensing is that invention can be converted into product, which may give you financial benefit. So this financial benefit is very important. So this licensing plays a vital role in technology. So again, I have mentioned this about COVID. Actually, when our country was in the second wave of COVID-19 and faced a shortage of certain COVID-19 drugs. So if you have seen the Vaccine War movie, many of you have seen, but it is the Marathi movie, so you might not have seen it. Just forgot, because that movie is based on the vaccination, how COVID and this Covishield and all these vaccinations. So ICMR first invented the Covaxin vaccine for this COVID-19. And Supreme Court of India as well as the Delhi court has suggested the government to implement compulsory licensing provision. Means as the invention is done by the government, the right of that invention goes to the government directly. So any pharmaceutical company don't have the right of it, production rights of it. So government has invented, and then they have given to the Bharat Biotech, and then Bharat Biotech actually do the production of this COVID-19 drug, and then vaccination drive was conducted. So this licensing of your patent is very important, because otherwise it will remain standstill. You have a patented invention, you have rights of your patent, and it is kept as it is in the file, and it just addition of your biodata. It will not work. So inventors should go for the licensing of the patent. Now this is just a scenario of the patents, and just to give you the brief idea about it. So in 2017, up to 13,045 patents were granted in India, twice as many as 2015. And after this, you can just see the scenario. It's a drastic change. So this is the Indian applicant patent filed in India in 1819. You can just see the change. TCS filed 239, then IITs filed 557. Then in 2019, these are the top US patent granted. You can just see the numbers. This is very important. So IBM has filed 9,262 patents in 2009. So for small part of maybe any PC or small part of your mobile, everything is patented. So you can just see how many patents they have filed in 2019. Now, this is according to NASCOM report, 5,000 IoT patents were filed in last 5 years. So 70% of patent came from the multinationals, 7 from startups, 95 from the IoT patents. So I can say that IoT patents filed, so 40% filed patents have been granted. So this is very important. So these are the just figures I have to give an idea before the scenario before 2015 and after 2020. So how many patents now people are filing in India also, and it's a drastic change. The latest International Intellectual Property Index 2021 released by the US Chamber of Commerce. So you can just see the India's rank to 40. So highlighting tangible improvement in its IP ecosystem. So it's a very good thing for our country. And this is the latest scenario of the patent filing. So during this year, I'm talking about the 2022. So a total of 66,450 patent applications were filed. It's an increase about the 13.57 as compared to the previous year. And you can just see domestic filing of patent application has also increased to 29,508. So which is almost 44%. So now people have understood the importance of filing the patent, and it's awareness is spread about filing the patent, copyright, and other IP also. And the government is also taking initiative regarding this, and they have many more amendments in the act also. So it's a very good thing for our country. Now this is just a summarized thing I have given here. So it's a maximum protection duration. So if it is a patent, then it's a 20-year. Trademark is a lifelong. Design, it's a 15 years. Copyright is 60 years. If it is a GI, it's a lifelong. So we have to renew every year. Actually, it is mandatory. So if you file the patent is granted to you for 20 years, then also you have to renew it every year. So it's a standard procedure for everything. But before expiry, you have to renew it. Otherwise, grants will go. So these are the 4 actually Controller General of Patent, Design and Trademarks. So this is under the Ministry of Commerce and Industry. So patent and design offices are Kolkata, Delhi, Mumbai, Chennai. So if you want to file it offline, you have to go to these offices. Trademarks is also in the major cities. They are having the offices. So yeah, so I am at the last part of this concluding remarks. So in the today's session, I have covered the introduction of the intellectual property rights, starting from its definition, then their types, then a briefing about their types, then how you can file the patent, what is exactly a patent means, how invention should be if you want to file the patent. What are the conditions that should be fulfilled by your invention? Then what is the procedure for filing the patent in India, in abroad, and what are the different sites available if you want to do the patent search. So all these things we have discussed in today's session. So each country has its own patent law. However, patents can be protected in many countries through this PCT application. So I have already explained this, what is PCT. And there is a need to file a patent to protect an innovative ideas and invention and take financial benefit. So licensing of your patent is very, very important. So these are the few points and concluding remarks. These are nothing but the some of the articles which are available on the website. So thank you so much for listening patiently, asking the questions, and it's a very nice to have the interaction with you all people. I'm from the Maharashtra, from Pune. So you are, I think, from the Tamil Nadu. And thank you so much for inviting me for this session. And if you have any question, it is open.
No, ma'am, you explained very well.
Yeah, thank you so much. If you have any questions, you can just...
Can you share the PPT?
Share means
I mean,
here?
yeah, no, not here, in WhatsApp or in mail.
Yeah, I will share, no problem.
Okay, ma'am, thank you.
Any other thing?
Thank you so much, Dr. Jayashree ma'am, for your wonderful session. I also thank the participants for your active participation. Thank you, ma'am. Next session at 12 o'clock, all participants request to stay connect the Google Meet. Thank you.
Yeah, thank you so much.
Thank you.